host of this program. We have two dignified resource persons, Justice Senthil Kumar Ramamurthy sir and Thiru Srinath Sridevan sir. Now, for giving an introduction for Mr. Justice Senthil Kumar Ramamurthy sir, I am inviting Mr. Cherukuri Rekhupati Vasanta Kumar, President DCDRC, Kakinada, Andhra Pradesh.
Vanakkam Puducherry. Dignitaries of the dais and of the dais. Very good morning to you. It's a very honor for me to introduce Justice Senthil Kumar Ramamurthy sir. Justice Ramamurthy sir was born in the year 1966, coinciding with the date and the month of the birth of Mahatma Gandhi, that is 2nd October. He obtained his bachelor's degree in law from Madras Law College in 1990. He enrolled as an advocate the same year. In 1992, he obtained his master's law degree in constitutional and international law from Madras Law College. He was also awarded a junior research fellowship in law by University Grants Commission. In 1993, he joined the chambers of Senior Counsel Aravind Datar. Sri Ramamurthy's areas of work during this time included mining law, amalgamation, and operation and mismanagement petitions under the Companies Act, suits, state petitions, and arbitration. He also acted as a counsel for many public sector undertakings and multinational companies. Mr. Ramamurthy continued to work in Datar's chamber until 1998, and he was elevated to the bench on 22nd February 2019 and became a permanent judge on 17/3/2020. Okay, thank you.
Thank you, sir. Now, for introducing Thiru Srinath Sridevan sir, I am inviting Mr. Chiranjeevi Nellapudi, President DCDRC, Vijayawada, Andhra Pradesh.
Good morning, Honorable. I thank to all the organizers and Ambedkar Law College and also participants. I introduce my Srinath Sridevan. Srinath Sridevan is the founder partner of HSB Partners, advocate and solicitor, Chennai. Srinath graduated with a gold medal in law from Madras University in the year 1996 and then went on to pursue his master's from New York University in the year 1997. After graduation, he got an offer from Ellen and Bowery, London, and started working there. Later, he moved back to India and started out with a new law office named HSB Partners at Chennai in the year 2004. He possesses an experience of over 20 years in the law industry with specialization in different aspects such as mining law, arbitration, corporation law, etc. Thank you.
Thank you, sir. Now we can start our session.
Good morning to you all. Honorable Chief Justice Sriram, Honorable Justice Sahi, Professor Vijay Kumar, Professor Srinivasan, where he is. Mr. Srinath Sridevan, ladies and gentlemen. Even before I get into my topic for the day, since the theme today is capacity building, I just wanted to share a few things with you. After about 30 years as a lawyer, I became a judge in 2019. A little under 1 year after I became a judge, I had the privilege of sitting with Justice Sahi on the bench. And I tell you, it was really like I had entered a Gurukulam. That was the kind of learning. And I say this because, you see, though I had spent 30 years as a lawyer, being a judge and adjudicator is a somewhat different ballgame. And, you know, there is so much to learn. So I was very thankful that I had the opportunity with him because his, you know, depth and width of knowledge is amazing. More recently, I've had the privilege of sitting with Justice Sriram. Now again, you know, there was a time we were hearing a public interest litigation and his eyes immediately focused on a photograph. It was a photograph of a building. I had also been sharing the bench with him. I didn't notice anything about it. He pointed at that photograph and said that the same photograph I saw in an earlier writ petition. Let's examine this. Sure enough, you had the government advocates for the respondents. The files were called for. It turned out that it was the very same petitioner. He had used the same photograph. The same thing happened another time with a temple. In both cases, we were able to conclude that it was an abusive process. What it tells you is that, you know, the power of observation, the photographic memory. See, there's so much to learn at any stage. So I would request all of you to approach this capacity building session by keeping in mind that, you know, being a judge is a learning process that's never going to end till you demit office. Even thereafter, of course, you're going to learn, but perhaps in a different capacity. So with this preamble, I will start my presentation. My focus for today is on healthcare providers and consumer protection. The expression healthcare providers is quite wide. So it embraces not only medical doctors, not only medical doctors in hospitals. If I can have next slide. It not only embraces medical doctors in hospitals, it also embraces nurses, paramedical staff. They could be X-ray technicians, they could be a lab technician, hospital administrators. They could be the owners of the hospital, they could be part of the management of the hospital, they could be part of the billing recovery teams in the hospital. You can have non-medical staff such as the ward assistants, theatre assistants, and so on. Of course, the health insurance staff who nowadays work very closely with hospitals. I don't have the time to really, you know, deal with all of this today. And I'm going to focus largely on medical doctors in hospitals. My co-panelist, Mr. Srinath Sridevan, is going to deal with the more, you know, exciting and interesting aspect of celebrity endorsements. So I'll leave that to him. Now, as far as medical doctors and hospitals are concerned, both the Consumer Protection Act 1986 and the current avatar, the Consumer Protection Act 2019, both of them provide for complaints in respect of defective goods or deficient services. So obviously the first question that has to be examined is whether services would embrace services provided by medical doctors in hospitals. Now, during the early days of this enactment, one of the objections raised to the exercise of jurisdiction by consumer forums was that these are professional services, and professional services are very different from other services. So the contention was that professional services are not intended to be within the scope of the Consumer Protection Act. Cases were filed across the country. In fact, my parent High Court, the Madras High Court, a division bench ruled at that point of time that services provided by medical doctors will not fall within the purview of the Consumer Protection Act of 1986. In fact, I distinctly remember at that point of time, there was this, headline across most of the newspapers in Chennai that quick justice should not become quack justice. It was a line from the division bench's judgment, and that was the view taken by the Madras High Court. The matter thereafter travelled to the Supreme Court, and the Supreme Court decided the matter in a case called Indian Medical Association versus VP Shanta. So that was the case where the Supreme Court concluded that there is no reason to exclude medical services from the scope of the Consumer Protection Act. So in doing so, what they did was, if you can please move the slide. Yes. So they first looked at how, service is defined under the Act. Section 210 of the Consumer Protection Act defines a service. Now you will notice that the opening words, service means service of any description. So it's extremely wide in scope. After which the second limb of the provision goes on to provide examples of services that fall within the purview of the Act. So specifically, they have mentioned banking services, financing, insurance, transport, etc. And then right at the bottom, you would find again, I've shown these important portions in bold. You will find it says, but does not include rendering of any service free of charge or under contract of personal service. So one contention in Indian Medical Association was that it's not, it's a professional service, so it should be outside the purview of the Act. Supreme Court negatived that. The other argument was these professional services are regulated by professional bodies, right? Earlier we had the Indian Medical Council, today you have the the Medical Commission of India. So these professional bodies regulate. It's the same with lawyers, we are regulated by the Bar Council. Chartered accountants, you have the Indian, Council of Chartered Accountants, you have similarly for cost accountants, you have for architects. So one of the defining characteristics of a professional service is self-regulated. Therefore, the contention was it should be outside. All these contentions were expressly considered in this judgment. You should notice that it's by a 3-judge bench in 1995. And the Supreme Court concluded that unless the service is provided free of cost to every patient, there also they even examined whether it should be, for some patients, every patient. They even examined whether if the insurance company is paying for it and you're not paying, would it be free? They said no, all of that is covered. And merely because it's self-regulated, you're not outside the scope of the Act. So ever since, services provided even by doctors and hospitals has fallen within the scope of the Act. Now, having said that, one of the reasons why I drew your attention to this is because today the governing statute is the Consumer Protection Act 2019. The Consumer Protection Act 2019 also defines service. That service you will find if you flip 2 slides. I think slide number 7, please. Yes. So here again, there is a definition of consumer first. Section 2, subsection 7, clause 2 defines a consumer. This definition has not really changed from the 1986 Act. Now, what about the definition of service? Definition of service is in subsection 42 of section 2 of the 2019 statute. You will notice that the definition remains identical, but for the words ing being added. Earlier it was board or lodging or board. It's more a cosmetic change that they've added the words ing. In fact, I think it's an error. Board is the correct word, but they've changed it to boarding now. But otherwise, the point I'm making is that the definition remains completely unchanged. But the question as to whether service would fall, professional service would fall within the scope of service, came up more recently before the Supreme Court in the context of services provided by advocates. This is in the case of Bar of Indian Lawyers versus V.K. Gandhi. You must notice that it's a two-judge bench of the Supreme Court. So the same arguments were advanced. Lawyers are, they are professionals. They are governed by the Bar Council of India. You have the Advocates Act. You have the Bar Council of India rules. The legislature did not intend to include professionals within the scope of either the Consumer Protection Act of 1986 or the Consumer Protection Act of 2019. It was also argued that the legal profession is sui generis, which is it is unique, it's unlike any other profession. And strangely, it was also argued that the service provided by an advocate is a contract of personal service. Now, the two-judge bench of the Supreme Court proceeded to accept these contentions. They concluded that the legal profession is sui generis. It was also concluded that the service provided by an advocate is a contract of personal service. If you compare and contrast this with the judgment in the Indian Medical Association case, again the question as to whether it's a contract of personal service or a contract for service was considered in that judgment. And the conclusion there was that for a contract of personal service, there should be a master-servant or employer-employee relationship. Otherwise, it cannot be construed as a contract of personal service. And this is a contract for services. Of course, Indian Medical Association was in the context of medical doctors. Now, in the context of advocates, the conclusion is that it's a contract of personal service and that the legal profession is sui generis. On these grounds, the Supreme Court concluded that advocates are outside the scope of the Consumer Protection Act 2019. So this judgment holds the field as of date. So if you're confronted with a case complaining of negligence by an advocate, it's outside your jurisdiction as of now. They also did another thing. They requested the Chief Justice of India to form a larger bench to reconsider Indian Medical Association. That was also done. And that reference went before a three-judge bench. Please turn to me. So then the three-judge bench of the Supreme Court declined to answer the reference. The reason they declined is because they said you've already concluded that advocates are sui generis, that it falls outside the scope of the Consumer Protection Act. So there's no need for us to answer the reference. They said that if in an appropriate case, there's a factual foundation for us to decide whether professional services are covered or not, we will consider it. So now the question arises, what is the implication of these two judgments? As I said earlier, Indian Medical Association is a judgment delivered by a three-judge bench of the Supreme Court. So as regards medical services, that will continue to govern. In fact, I would say that it will continue to govern as regards all professional services other than advocates. That is how you may have to proceed. That's the only practical way for all of you as adjudicators now to deal with these two judgments, unless the Supreme Court decides to revisit the one or the other. The possibility is there, but until then, this would be the position. Now, having concluded that
today the law is that medical doctors, hospitals are governed by the Consumer Protection Act. The next question would be, on what standard are you going to decide whether there is negligence by a medical doctor or hospital? During his address, Chief Justice Sriram was alluding to how complicated these things can be, right? Because ultimately, the complainant is usually a layperson. In the odd case, it may be a medical doctor, but otherwise, the consumer is typically a layperson. The members of the panel of the Consumer Commission, unlikely that there will be a medical doctor in that panel. So how do you conclude whether a medical doctor or a hospital has been negligent in providing services? Now, the classical test was laid down in this case called Golub versus Supreme Hospital Management Committee. It's a 1957 judgment. It's referred to as the Golub test. Now, what is this test? The House of Lords decided that a person is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. So, obviously, it means you will be calling for expert opinion, because that's the only way you will know. If you were to apply the Golub test, you will have to call for expert opinion to find out what would be the opinion of a reasonably skilled person in that particular discipline. Now, let us say you're dealing with complainant who was admitted for, let us say he was admitted for a cardiac bypass surgery. Obviously, you will not be turning to, a pediatrician. You'll obviously have to turn to a cardiologist, either a physician or a surgeon, or perhaps both. Now, you don't look for the highest standards of skill. You look for a reasonable or an average standard of skill. And then you're supposed to test it based on the opinions of experts. Now, certain questions can arise. Is that opinion binding on you? Right? Expert opinion under Section 45 of the Indian Evidence Act, the latest avatar is in the same terms, provides for expert opinion, but expert opinion is not binding. This ratio seems to indicate you need to go by expert opinion. But courts, not only in India, but across the world, have moved away from the Golub test. I will not go to the extent of saying that the Golub test has been discarded, but it's been diluted over time. And that trend, is seen in decisions of Indian courts as well. Let me move on to explain to you how the trend changed. But before I do that, I will also deal very briefly with a rule of evidence which is very central in medical negligence cases, namely the rule of res ipsa loquitur. Now, res ipsa loquitur, it translates into the thing speaks for itself. The very expression should give you an idea that negligence should be writ large. If on examining the record, like let us assume that somebody goes into hospital for a simple knee or ankle operation, the man dies, right? During surgery, he dies. It may well be a case where you may be able to rely on res ipsa loquitur, because it's not likely or probable that somebody goes for a simple knee or a ankle operation should die on the operating table. But a patient who goes in, let's say after having a heart attack or after having a stroke in the brain, it may be very difficult in those circumstances to readily rely on res ipsa loquitur. that is why, in multiple cases, the Supreme Court has dealt with res ipsa loquitur. In Syed Akbar, they, use this expression, they say, the rest must not only bespeak negligence, but pin it on the defendant. So it should point also to the defendant's negligence. Only then can you fall back on res ipsa loquitur. And the other case which I've just for illustration purposes, I've given you some of these cases. In Bombay Hospital, which is a 2021 judgment, what happened was that the conclusion that the doctor was negligent was entirely on the basis of res ipsa loquitur. Eventually, when the Supreme Court examined the medical records, they said that there's no way you can hold this doctor negligent. The records seem to indicate that reasonable care was taken right through the process. So you cannot then draw a conclusion entirely based on res ipsa loquitur. Now, with this, I will go back to how the Bolen test has evolved. Right? First, how it has evolved globally. Please turn to the next slide. This one. No, go back. First, how it has evolved globally. A judgment called Sidaway was a significant judgment in which they looked at the right to be informed. See, today, under the Consumer Protection Act, one of the critical rights of a consumer is the right to receive information, the right to be informed. So medical negligence, started to be looked at from the perspective of the patient's right to be informed of the risks that are attendant with any medical procedure, so that the patient can then take a decision. Now, who is to decide whether to part with the information? Obviously, it is the doctor who has to decide whether to part with the information. So, is that a judgment to be made on purely medical terms? Or should the doctor also take into consideration the perspective of the patient? Now, suppose a patient is informed that, look, for your, let's say, cardiac condition, I can treat you with drugs. But if I were to treat you only with drugs, there is, let's say, a 10% chance that you will develop a heart attack within the next 6 months. Now, the patient then may ask himself, look, this surgery is going to cost me, let's say, 1.5 lakhs or 2 lakhs, right? The risk is 10%. Given my economic situation, I don't want to spend that money, I'll run that 10% risk, right? If you're looking at it from the perspective of the patient, then, all those non-medical aspects will come into the equation. Also, you see, the patient may be, let's say, of a certain age, when the patient feels that I don't want to run the risk of surgery. And this could vary from patient to patient. Even two patients of the same age may have a very different approach to this. So, in Sidaway, the court concluded that it's a medical judgment to be made by the doctor. And they also said that you need not disclose if it's going to be detrimental to the health of the patient. Now, let us say it's a patient who's very critical. And if you were to inform that patient that, look, there's a 60% chance you'll die, it's quite likely it may have a very adverse effect both on the physical and mental health of the patient. So then, can the doctor take that into consideration? So in Sidaway, they said definitely it's something that the doctor can take into consideration while deciding whether to disclose or not. And the disclosure is necessary only if it's a material risk. But it was all supposed to be done on the basis of a purely medical judgment. Subsequently, in this case called Montgomery, the UK Supreme Court again had occasion to deal with disclosure to a patient. This was in the context of a pregnant woman who was suffering from diabetes. So, in pregnant women with diabetes, the babies are likely to be larger. And since the babies are likely to be larger, it is possible that the baby may have what is called shoulder dystoxia, which means the shoulders are too large to be, delivered normally through the vaginal tract. So the question that arose in this case was, the doctor did not disclose to the patient the risk of shoulder dystoxia. This was roughly a 10% risk. And if there is shoulder dystoxia, there could be further complications, including failure to maintain the requisite oxygen supply to the baby. That risk was very minuscule, probably less than 1% of cases. But in this particular case, on the facts, that's what happened. So the woman alleged negligence, saying if the risk of shoulder dystoxia had been communicated to me, it's a 10% risk. I consider that a significant risk. I had the option of going in for elective cesarean. I would have exercised that option. So the Supreme Court of the United Kingdom accepted that contention and concluded that you need to disclose as a doctor any material risk. How do you decide whether a risk is material? You decide whether a risk is material by asking yourself what a prudent and reasonable patient in the position of that patient would consider to be significant. If a reasonably prudent patient in the situation of that patient would have considered it significant, the risk, you have to disclose. So here, because the risk was 10%, the Supreme Court concluded that it should have been disclosed, and non-disclosure amounts to negligence. In fact, interestingly, what the doctor said in this case in evidence was that, look, if I had disclosed, every diabetic pregnant woman would opt for elective cesarean. That would be the downside. That is why I did not disclose. But then they said that that proves that it's material, because then the patient would have elected for a cesarean instead of going for a normal delivery. So that is how these standards have evolved globally, and Indian courts have also followed suit. If you please turn up, yes. So Malay Kumar Ganguly is a 2009 judgment of the Supreme Court, where what happened was a patient had a skin condition and was administered steroids for an extensive period of time. So this resulted in sepsis and death of the patient. So in that context, the question was whether you strictly apply the Golem test, whether the doctor was negligent. This was a case where they also examined criminal negligence, whether 304A is satisfied. Eventually, the conclusion was that it does not meet the requirements for criminal negligence, but it meets the requirements for civil negligence. This Maharaja Agrasen Hospital, a lovely judgment, I think Justice Indu Malhotra's judgment in 2020. This was a case relating to a preterm baby. And with preterm babies, there is the risk of developing retinopathy. So it's called retinopathy of prematurity. This risk, the patient said, had not been disclosed at all with regard to her baby. What the hospital did was they said yes, the test was done. Then, the Supreme Court examined the medical records thoroughly. And although a record had been created that the test for retinopathy was done on a particular date, the Supreme Court concluded that the evidence lacked credibility because, it was just one noting on a particular date. They even looked at how that note compared with earlier medical notes that had been made by the hospital and said that this had been created subsequently to make it appear as if this retinopathy of prematurity test was carried out. And in this judgment, Justice Indu Malhotra has gone a lot into the duty to disclose. All the global judgments have been taken into consideration. Judgments like the Sidaway that I referred to, Montgomery. There are judgments from the Australian courts. I think Rogers versus Whittaker, a judgment of the Australian court. There are a few judgments of Canadian courts as well. In all these jurisdictions now, the trend is towards recognizing the patient's rights, especially the right to know, the right to then take an informed decision. So that is how the Bolam test has evolved, and most recently, the Supreme Court, in fact, in December of this year, decided a case relating to a problem with the eye, endophthalmitis, which occurred after cataract surgery. It was due to poor post-operative care. This was also held to be negligent. Now, the common thread you will find running through all these cases on medical negligence, especially with regard to doctors and hospitals, is that it's all evidence-based, right? I don't know how many people without a legal background are there in this hall. Not too many. Not too many. But, the point is that, especially in the context of medical negligence, decision making, has to be completely founded and based on evidence. I think that is the most critical aspect to be borne in mind. Sometimes I think it can be a challenge because the consumer court is supposed to adopt a summary procedure, right? So how in course of a summary procedure do you ensure that requisite evidence is on record? That is one of the reasons why, in the early years of the Consumer Protection Act, several high courts concluded that these matters should be referred to a civil court. But even now, interestingly, if you look at the Indian Medical Association judgment, if I'm not mistaken, I think it's paragraph 37 of that judgment. The Supreme Court records that the Consumer Protection Act is not in derogation of other statutes. It's in addition to other statutes. So, if the case is very complicated, you have the option of requesting the complainant to approach a civil court. That option is available. And I suppose, you may need to use your discretion. There will be a number of cases which are fairly straightforward, where you may be able to even invoke res ipsa loquitur. On the other hand, there may be a case where you feel a really full-scale trial is necessary, right? And then you may have that option of requesting parties to, go to a civil court.
Sir,
for
but
adjudication.
in my opinion, instead of going civil court, going to the consumer court is best because in the social incident legislation, that to a poor consumer cannot approach the ask the court which requires too much of procedure. But in consumer court, there is a summary procedure and also it will be available very cheap and poor patient also can go. That's why it is
I think you are right. That is, after all, the object and purpose of the Consumer Protection Act
that it is expeditious. At the same time, what the point I am trying to make is, you have different kinds of cases that come before a consumer court. Even medical negligence cases are of different kinds. There are cases which are amenable to being resolved summarily. There are cases where you need more extensive evidence. So you cannot treat everything similarly. That is the limited point I made. So all I will do is I will conclude by underscoring the importance of evidence-based adjudication. I would recommend that all of you read this book. It's not a book written for lawyers. It's a book written by a lawyer, but it's not written for lawyers. It's called The Proof, Uses of Evidence in Law, Politics and Everything Else. So the point the author makes is that decision making, not only in law, it could be decision making by a professor who's evaluating students. It could be decision making by a policeman, right? In so many contexts, it could be decision making by policymakers. In all these contexts, evidence plays a role. And ultimately, any rational decision has to be grounded in evidence. The kind of evidence, the standard of proof may vary. We know, as between criminal law and civil law, the difference in the standard of proof. You may be even adopting lower standards than even balance of probability in a different context, outside the law. Nonetheless, whatever be the context, any rational decision has to be evidence-based. It cannot be based on hearsay, it cannot be based on some newspaper report which is not on record, it cannot be based on some television interviews and, presentations. So thank you very much. I leave it to Mr.
Just go to the next slide. I want to see if all the fonts are problematic like this. Super. Okay. Thank you. Ladies and gentlemen, this is Sati. This is Sabdukumar Ramamurthy. The difficulty of coming after a great speaker is that people either want him to wind up quickly so they can get back remembering what he just heard, or that people are still engrossed in what he said. And I am engrossed in what he said. Although I appear on the surface to be speaking about a different topic, which is celebrity endorsements in relation to the healthcare sector, this topic was chosen because the common thread underlying all that you've been hearing this morning is this. It is that consumers have a right to information. And information is disseminated through several media. Traditionally, we had advertisements which were prepared by the provider of services or the producer of goods, and these advertisements often had very popular or attractive people saying things, and there was one advertisement which is one message, and that message was spread across crores and crores of viewers over the television or radio or magazines. Now something revolutionary happened over the last 10 to 15 years, which is the growth of social media. And in that process, we started having individuals who conveyed the messaging or the information of producers of services, providers of service or producers of goods, and these were then taken by consumers as part of the decision-making process to hire a particular service or purchase a particular goods. Sure. Thank you. The difference between these kinds of advertising is very obvious. I mean, I have some slides for you to look at, and we'll go to them in a bit. But the point is this: in services like healthcare and law, we have traditionally not been allowed to advertise. Therefore, most of us relied upon word of mouth. Therefore, someone would say that so and so is the best cardio or the best nephro, and then we would have a word with that person, and then if we were satisfied, we would go and meet that particular cardiologist or nephrologist. Same thing goes with lawyers. But what we are finding in the ever since the growth of social media is that persons whom we don't know offer us word of mouth advice about services or goods. So then the question comes as to why is it that we take these people seriously? Now, that is a human failing. So, for example, if someone stylish like Mr. Senthilkumar Ramamurthy says, I use only Mont Blanc pen, next minute I'll be in the shop. What do you think? You do it, must be very nice. So, can we go? Thank you. So this human failing is based upon several things which we all know as part of our knowledge of humankind, which is that people are vulnerable. When we lack knowledge, we decide to go with the herd. So, for example, if someone says lunch in 1 o'clock, everyone will go. We won't even think that, okay, if we all go the same time, there'll be a big queue. But we follow the group. Now, who are influencers? Influencers are people who have got a wide following in social media. And therefore, let's say, if Virat Kohli says something, he's going to have 20 lakh people see it the same day on one of his social media feeds. Now, keeping this in mind, the first set of regulations came from the Advertising Standards Council of India in 2021, which gave certain guidance. I'll go into this in detail in a short while. But the essence of it is this. When I say something to you, or when Virat Kohli says something to you, not specifically to you, he says it on his social media, but the way it comes across to you as though he's talking to you one-on-one. You have to know, is he saying it because he thinks it's good or because he's being paid to say it's good? And that is the essence of information. You all heard the learned Chief Justice speak to you this morning. He spoke about consumer rights and the concomitant duties. What are the duties in relation to the provision of healthcare services or information relating to healthcare services through the use of these influencers or celebrity endorsements? You have a right to know A, information that is accurate, and B, whether the person who is giving that information knows what he or she is talking about. So, for example, if a very popular actress, says that I use only this toothpaste, but the question is this person making a conscious decision based on knowledge, having tested multiple toothpaste, or is she doing it because she's paid to do it? And this is the essence of what we're talking about. Can you go to the next slide, please? So, I told you that I'll present you with some data on this. And the growth of celebrity endorsements is is exponential because what people find is that 61% of people accept influencer recommendations. So we accord to influencer endorsements the same respect that we would give to word of mouth recommendations. And that makes it a very powerful channel for sending information about goods or services. Now, this becomes all the more important when we apply to the healthcare sector because our lives depend upon the quality of information we receive and the decisions that we make based on that information that we receive. So, and now go to the next slide, please. Now, there are celebrities who use this as a positive tool. I'm going to give you 3 positive examples and 1 negative. So, Madhuri Dixit, she said that breastfeeding is a positive thing. Next slide again. This is for COVID vaccination. This actor called Sonu Sood said we should get ourselves vaccinated. Next slide. Virat Kohli said that if you're going to consume so much carbohydrates, make sure you consume protein. All of these things. And he said, and the other person said how much you should sleep and you should not be. So these are good messages, and these are messages which everyone says are true. And these kinds of messaging have now been given a statutory recognition by the Ministry of Consumer Affairs in its guidelines, which I'll talk about towards the end of this session. But then we have one negative one, which also became a case which many of you may be aware of, where a very popular actor modeled for. It used to be called Fair and Lovely, but in this ad it showed as Fair and Handsome. And,
Glow and Lovely, sir, it has been changed now.
I know. And the question is why it changed. See, and that's my point. See, the minute we put someone like this in space, everyone is noticing it. And that is very important because that is the power of social media, because we're all looking such a good looking man and he's saying that, we should all be fair, we should all be handsome. But the question is, this messaging, nothing wrong in saying that you should take, anti-tanning because UV rays are bad for you. That is fine. But the minute you create a messaging that being fair is somehow connected to being handsome, there's a problem. I mean, we are all evolved enough to know that these things are problematic messages. Next slide, please. So now the question is, should the Consumer Act step in? And what we find, and this data again is from a very well-established source, it shows that 80% of people will believe things which celebrities tell them. Now, it is this mindset which has driven the changes which we see in the Consumer Protection Act of 19. We have a specific provision dealing with celebrity endorsements because people are more likely to believe what a celebrity says. Now, in India, we don't yet, unlike the West, we don't have celebrities saying, take this tablet or take that tablet. So, to that extent, we are better off. But we do have a slightly lower level of healthcare products or quasi-healthcare products which are being pushed by celebrities. And the question is, so for example, a baldness treatment or a dental treatment, these are all things which celebrities are quite happy to say. But the question is, if a problem arises, is there a liability? Can you go to the next slide, please? So the regulatory framework, I just tell you to listen to me. The regulatory framework is in 7 instruments. One is the Drugs and Magic Remedies Objectionable Advertisements Act of 1954. Then you have the Consumer Protection Act of 2019. Then the Advertising Standards Council of India issued something called the Influencer Guidelines of 2021. Then the Ministry of Consumer Affairs issued 3 guidelines, one in 22, one in Jan 23, one in August 23. And it issued a further addendum later in August 23. So these 7 together contain the body of regulations. Let's first talk about the Drugs and Magic Remedies Act. Let's hope this font works.
Corrected.
Where is? Oh, it's not corrected. I don't know. I think there's a version issue. Maybe we should have had it checked before we did this. My mistake. But it's all right. It's nothing visible. Is it visible there?
Yeah, this is.
Is the text visible? No, it's not. I'm so sorry. I should have probably changed the font. So this act prohibits the publication of advertisements.
Yeah.
That,
Can we convert the text? Other
oh,
font.
good job.
Yes.
Thank you. So now this act has a schedule. The schedule has a long list of diseases or ailments, and the act prohibits a promise of treatment or the provision of drugs which can cure these diseases. Now, when I was much younger, I did a case where there was this gentleman who had seen one of these ads on late night TV, which advised him to go to a particular Siddha doctor for his sexual performance. And so he followed it, and who knows whether the Siddha doctor was truly qualified or not, but he took this treatment, and after some years, he found he had heavy metal poisoning, because treatments do involve use of metals. He found he had heavy metal poisoning. He approached the consumer court. I had argued the matter on his behalf, and the State Consumer Commission found that one, you cannot in the advertise or make an assurance of cure of any of these diseases which are in the schedule to this 1954 Act. And second, of course, the Commission also found negligence in the matter of treatment, namely that you can't, under the guise of following a native system of medicine, poison someone, which I think is self-evident. And so this is one level. But you also find, and I had a very interesting conversation with Chief Justice Sahi this morning, and you also have several cases where you have medical establishments not promising to cure, but providing information. Now, is that prohibited? And the answer is this act doesn't prohibit provision of information, it only prohibits promising of cures. It says no magic remedies. So you can't say that, juju magic and these scheduled diseases get cured. Next slide. Thank you. Okay, so then we come to the 2019 Act, and it deals with endorsements. And we all know what endorsement means. I am dealing specifically with endorsements in relation to the healthcare sector. Now, one of the very important points that we heard Mr. Senthilkumar Ramamurthy tell us about is that what exactly falls within the meaning of the word service insofar as the healthcare sector is concerned, and we learned from him about the Indian Medical Association case. Indian Medical Association was VP Shanta. Now, the interesting thing here is this. We had the 1986 CP Act, which had 210, which defines service. Then we had VP Shanta, which interpreted, Indian Medical Association was VP Shanta, which interpreted 210 in a particular way. Then we had the 2019 Act, in which 242, with barring the minuscule cosmetic change which Justice Ramamurthy mentioned to us, virtually adopted the same definition as 210. Now, what does this mean? There is in common law a principle called the Buckmaster Doctrine, which was laid down by Lord Buckmaster in the case called Parras versus Aberdeen. It's a very interesting doctrine. He says that where a provision of a statute is interpreted by a superior court in a particular way, and that law is amended, reenacted, or replaced thereafter by legislature using the same words, the legislature is deemed to have accepted the interpretation placed upon that provision by the superior court. So it seems to me that when 242 was brought in the 2019 Act, the legislature did not want to tinker the definition because they felt that in relation to the medical sector, VP Shanta was the correct law. But now with the Bar Association case, now the cap has been set amongst the pigeons. We'll have to see how the law settles. Of course, I just learned that I was desperately trying to look it up while you were speaking. I just learned that the reference was declined. I was not aware of that. Thank you very much. So for now, we proceed on the basis that the healthcare sector is covered, and therefore endorsements in relation to healthcare are equally covered by the Act. Can you just move forward next slide, please? So the powers are given to the Central Consumer Protection Authority under Section 21. There are four. So what they do is this: there is first an investigation conducted by the CCPA into an endorsement. They first examine whether the endorsement is false or misleading or prejudicial. Then they also look at their own guidelines. What are these guidelines? These guidelines include a requirement. It imposes a duty on the celebrity to undertake a due diligence on the product he or she is endorsing and satisfying themselves that what they are saying is true. That needs to be done before they can endorse. So if you don't do it, then CCPA can discontinue the advertisement, or they can impose fines, or they can issue a cease and desist order against the celebrity saying don't endorse anymore. All that is there in 21.3, and then you have 21.4. And as against this order, the CCPA under Section 24, there is an appeal to the National Commission. You can just
Change.
yeah. Okay, you can go forward a couple of slides. 3, I mentioned all this, and then 5. So, no, just run back to that. Thank you. So, there is a safe harbor even in 21, which is if the celebrity has exercised what is called as due diligence, then he or she is entitled to, doesn't have a liability under Section 21. I'm going to just take a small detour to a very interesting case, which is a Converse case. So there is this gentleman who is a self-styled, he exposes all big brands. And what he did was, he has also read he also read up some medical stuff, and he's not a doctor, he's not a qualified doctor, he's not a qualified nutritionist, but he has done some reading. And I know this is Sivakumar Ramooti asked to all of you are non-lawyers, to all of you are lawyers, and towards a big majority, we all know these clients who will read up law and come and kill us. So this man is like that, but to doctors. And what he did was, he, through his social media page, made a post about how Complan is hoax and it is very bad for the health, and he said that there's so many false and misleading things in Complan. And so this is a Converse case. So Complan went to court against him saying he is not a qualified nutritionist, he has not done any due diligence. How is he entitled to disparage my product? And Delhi High Court held that applying the very same guidelines which are used this way, that is, manufacturers pushing products to endorsers, they apply the very same guidelines, the reverse direction, namely that celebrities cannot make a negative endorsement against a product unless they've exercised due diligence or they're qualified to do so. That's a very interesting case of the Delhi High Court. I think it is called Zydus Healthcare. Yeah, we can go to the next. So then we come to the influencer guidelines of 2021, which these were issued by the ASCI. These contain certain principles which now form part of the, which have now become mandatory. Although at that time they had no statutory force, what did they say? They said that one, no endorsement should be made unless you know it to be, unless you have done due diligence to ascertain that what you're saying is true. Second and most importantly, if you are doing a paid endorsement, you must say so. You can't, act like you're genuinely pushing something when you're being paid to do it. Why is this? Because you have to now go back to the pre-social media days. If someone came to you saying that I know XYZ, Dr. XYZ is a fantastic cardio, but I should tell you this, he has paid me to come and tell you this. Then you immediately say, oh, okay, fine, then thank you, and you stop listening to them.
Dr. Ambedkar Government Law College for taking lead for organizing such program ever since last year. Yesterday, our host speaker, Sri Abhinav Gupta, while unveiling the canvas of a 3-day program, created an impression in our minds that today is going to be a feast of knowledge. And also, our principal sir of Ambedkar College, he just mentioned just before the session that it is going to be a brainstorming session, sir. And also, again, Abhinav mentioned it is going to be a jugalbandi. So, it was like we were thinking it is going to be a treasure hunt for all the participants. So, really, sir, it was a treasure for all of us. It is a treasure of knowledge for all of us. Thank you, sir, for sharing the knowledge of consumer awareness with all of us. Thank you for sharing the knowledge. Indeed, it was a knowledge fest for all of us. Honorable Justice Sri Senthil Ramamurthy Garu, your humbleness was commendable, sir. The speech of yours started with the learning, the stress was given that the learning process will never end. Though, sir, you stepped onto the highest peaks of your career, I could observe the humbleness. The more knowledgeable you became, the more humble you are. The more humble you become, and the more experienced your wisdom you share with others. That was my observance. Thank you, sir. And the stress was on quick justice should not become quack justice. And the important judgments were shared with us in the form of various slides, like VP Shanta's case and various other cases like the Bolam case, and many other cases were shared, and importance was given on rule of evidence, res ipsa loquitur. Sir, I also happen to give a ruling on basing on this. Happy to share this from this dais. And one more thing is that the memory is commendable, sir. The paragraphs from the judgments you quoted was commendable. 37 paragraphs, sir, 37. And proof of evidence should be given importance. That was, and that should be underlined. That was the point to be important. That was, I think, every one of us to be, every one of us should underline. We all do that, but again, we should underline it. The other thing, one more thing is Jugalbandi. Again, I'm reminding it. Abhinav, yesterday, I think today he made that word brought to our notice that it is going to be a Jugalbandi. Yes, I was thinking it will be a tune of Jugalbandi, but like last time, it was Jugalbandi between Sriram sir and one more, I don't remember, but it was really a Jugalbandi. But today it was like one-on-one. They were countering. Two high court judges were countering each other. It was really a Jugalbandi. But today, since it is a bar and bench, it could not be a Jugalbandi. But it started with a Jugalbandi. The ball was thrown on the bench by Bar, saying that a stylish man like Justice Senthil Sriram Murthy, if he states something like this advertisement, the bar thrown a ball on the bench. So that way it was a Jugalbandi. So we experienced a Jugalbandi today. So the second the second speaker, Srinathan Garu, the word of mouth, he started how the human mind is getting influenced from the ancient to the nowadays advertisements, from the mouth of God to the social media. And he quoted with the data also, 61% it is getting influenced to the advertisements, and also that he also referred to the guidelines of Ministry of Civil Affairs, and also about various positive and negative advertisements. And I know, sir, about the influence the advertisements cause. Advertisements cause a hodgepodge on the health of the consumers as a certified, qualified nutritionist, and also the misleading advertisements. And They are asking me to wind up. Because yes. Thank you, sir. Thank you for providing your knowledge and giving us this opportunity. For all the participants and for giving me also this opportunity to thank you both.
Thank you, ma'am. By this, we are ending the first session and moving on to the second session. I'm inviting Honorable Mr. Justice A.P. Sahi, sir, our respected resource person for the second session.
சரி இதுல இருக்கும் இதோ பாக்குறேன் ஒரே நிமிஷம் இருக்கு
இருக்காங்களா?
இருக்கு இந்த சேவ் பண்ணிட்டேன் இருக்கு இதை பார்த்து இதானே வந்து
Thank you very much, Dr. Srinivasan, and thank you very much, participants. But thank you very much, participants, because as Mr. Srinath, the senior advocate, one of the most versatile advocates in Tamil Nadu, he says it becomes difficult when you have good speakers, when your task is still higher. I candidly concede to that proposition, and I think I will be encroaching upon your lunchtime a little bit. So, all speakers who have spoken have contributed towards this negligence. And I will plead guilty, not guilty. Therefore, my task is heavier, but nonetheless, what a brilliant exposition by both of them, and a no less brilliant vote of thanks that we heard just now. It was really a tribute to both the speakers to recognize that combination and to thank them for what they have. As a matter of fact, workshops should always include such speakers who not only come to talk but to deliver. Because talks, they vanish. But something which is delivered is received. And I could very easily see that it has been received with very apt attention by everybody sitting here with all their pencils and notings. And as a matter of fact, I was also noting down many things. So we are all in the learning process, as our Honorable Chief Justice conveyed to us. These speakers made you conversant with something which is known as contemporary law under consumerism. I had been asked as to what will you speak. I said, you give me anything to speak. There is no problem in speaking because I am at the helm of affairs, so I can communicate everything that what problems are being faced at the district level, at the state level, or any level for that matter. Jurisdiction and functioning. You heard Justice Senthil Ramamurthy talking about evidence and summary jurisdiction. And this I have been speaking at every forum. Please keep in mind, and I have learned it from Professor Vijay Kumar also, that because once I have conceded and pleaded guilty, I will name all the conspirators in it. So, we are not an adversarial jurisdiction. We are an inquisition. So, this is the jurisprudence section of understanding the jurisdiction of consumer commissions. Functioning, not marred by procedural tangles. After all, what is procedure? Whether it is civil procedure or criminal procedure or Bharatiya Danda Samhita or any law for that matter, evidence, limitation. These are all rules, codified rules of natural justice, which come to the aid of the decision-making process. But there is one problem with tribunals. Please understand this, honorable judges and advocates who speak, or even the Honorable Chief Justice, I have also spoken with from that platform. There it is a perception of a constitutional court where the width of powers is immense. But what is this tribunal? All of you know it is a creation of a statute. So if it is a creation of a statute, you derive your powers only under the statute. You don't enjoy constitutional powers as the High Court, they can interpret. But you have to follow the law. You are sailing within the banks of the river of the statute. You cannot, because if you do it, then you either sink or you sail. Constitutional courts have no limitations to that effect, even though they are also under the Constitution. I know Professor Vijay Kumar will correct me that nobody is above law. But nonetheless, the limits of the law have to be understood. And why I am saying so, very recently, I had to pronounce on it. The reason is that unless you define the banks, you never know how to navigate. So, it was a case, there were two cases, one from Bombay, the other came from Delhi. The Bombay case, there was a date fixed in a matter, and
the lawyer who was representing the complainant in that case, in a builder-buyer dispute, orally made a request to the bench, to the district commission, that I am not there to attend the case on the date fixed, please prepone it. And that was orally accepted by the bench. And the preponement was just one day before. 10th was the date fixed, it was preponed to 9th. Now, how do you inform the other side of this preponement? No orders on the order sheet, except for a message mailed by the lawyer herself from her private email ID to the counsel for the other side. And that is all. Full stop. The case is taken up on the preponed date and disposed of. Now the issue is, can this be done? Don't say yes or no, because in law there is nothing absolute. What can be yes for me can always be a no for Professor Vijay Kumar. And I think it is right, because this is how the law grows. The certainty of the law comes out of the development of the law, not on the fixity of an idea. Otherwise, science would not show any progress. Even though in law we need certainties, we don't need chaos, because this is a system of governance. So governance always requires a certainty, and that is why law requires certainty. And that is why the law of precedents. But nonetheless, in another Delhi case, date fixed, and the order passed is issue court notice. The notice does not emanate from the district commission. The lawyer says that I had sent a mail from my email ID address, which has been received, and this is not contradicted. So if it is rules of natural justice, the person has knowledge, very well, knowledge is there is no doubt about it. Knowledge can be oral, it can be communicated digitally, and digital information is permitted under the law. But the question is, by whom? The question is, today it is the lawyer, tomorrow it will be a lawyer's clerk, the third day it would be the litigant himself, that I had talked to the bench, they said this date. Can this be permitted? So, for a tribunal, if the procedure prescribed by law is there, I had to enter into it. Of course, it was argued by the council also, and I entered into it. And then traversing, this is the latest decision pronounced from 23rd December 2024. I have a hard copy of it, but you can download it. These days, Confonet is not working properly.
Yes.
So there is a problem in that. That is why I bought a hard copy. So this is revision petition number 3134 of 2024. Messrs. Sufosha Realcom Private Limited versus MS Divya Sharma. And there, the age-old principles of procedure prescribed by law. So procedure should be followed as prescribed and in no other manner. That is the age-old principle, and I say this because we are tribunals, or High Court, or for courts to adopt any other alternative mode of service. It may be open, they are higher courts, they are courts of plenary jurisdiction, even civil. But tribunals, for the time being, when the statute prescribes, so please carefully read section 65 of the 2019 Act. Service of notice is the caption.
Yes.
And then there are regulations. For example, even for digital information,
The regulation says, regulation 10 of the 2020 regulations. It says that there shall be a service provider. Then it says the service provider shall be of repute. And the third thing it says that the commission shall take a surety from it. So these three things are provided. So how does the lawyer become a substitute for a service provider? That will again be not in accordance with the procedure prescribed. The reason why I had to deal with it, because the defense of that person had been struck off. He said that there was no notice from the court. Often notice and accompanied by a complaint.
Yes.
That is the requirement of law. So this notice, sending of notice does not amount to that. We had to hold, yes, this is correct. And when we opened our mind in court that we are likely to do this, the counsel for the other side practically conceded that this will take unnecessary, I don't want to file any affidavits, please decide it, send it back so that the matter proceeds. I congratulated him that you have acted like a prudent lawyer because these days lawyers, they keep on thinking of dates and fees and adjournments and all those things. But nonetheless, he was, and I said this to him, that it will benefit you. But I don't think so, your client is going to benefit out. But at the same time, you must also keep in mind that whenever you are interpreting rules of service, the general principles, age-old principles should not be forgotten when it comes to this, that whatever is provided under the statute, no other method can be adopted, but the converse is, whatever is not prohibited can also be permitted in rules of procedure. And I will only request you to read it because it is a piece of poetry in the legal world. This is a famous dissenting judgment of a very famous judge, illustrious judge of the Allahabad High Court, who was elevated at a very early age, in his 30s, directly by the British government after having read his judgment as a magistrate, none else than Justice Magnus. So he delivered his dissenting opinion sitting with British judges in 1882. I brought this judgment because it is, I'll just read 3 lines because that will help you to understand how brilliantly the phrase was used to understand what is the procedure or natural justice procedure. If not prohibited, why is it permitted? I may therefore at the outset state that according to my view of the rules of construction applicable to the Civil Procedure Code, the courts are not to act upon the principle, that every procedure is taken as prohibited, unless that every procedure is to be understood as permissible, till it is shown to be prohibited by law. As a matter of general principle, prohibitions cannot be presumed. Of course, the High Court, Supreme Court, no. They are not tied by the rules of procedure. If they are tied, how will they defend fundamental rights? But here it is legal rights statutorily controlled. And the procedure therefore has to be followed. So he goes on to say, therefore it rests upon the defendants to show that the suit in the form in which it has been brought is prohibited by the rules of procedure. So this is the principle that you have to keep in mind, that at times you can find some space in the rules itself, then please exercise that discretion. Don't say that, no, I read it. Correct? No. If it can be accommodated, please do accommodate it. But if it cannot be, then you are bound by the procedure because you are a tribunal. So this is one thing which I wanted to speak about, the exercise of jurisdiction and the functioning of tribunals. You have to take care that when it comes to service of notice, this is just a 20-page order. You will not take time to read it, but you get everything consolidated. Now, I was in New Delhi on New Year's Day, and those of you who are conversant with the shopping areas of Delhi, there is one Khan market. Yes. Fortunately, my grandson was there. I was strolling with him. Then I saw a huge crowd encircling somebody, and on New Year's Day, everybody taking bites. And how do you feel this and how do you feel that? It is now in the social media also, but you will find it on the YouTube. A couple, the gentleman was 102 years old, and his spouse was 97 years of age. So they were, as usual, in a shop, walking perfectly in the pink of health. So they asked them, rather both of them, what is the reason for this grand old health of yours? You are 102 and your spouse is 97. Both of them had walking sticks. The gentleman was a retired Lieutenant General of the Army from Himachal Pradesh. His younger brother also retired as a general, both were in the army. And they had driven 10 hours from Shimla, slowly of course, 10 hours they took, to celebrate New Year's in Delhi. So the question was, what is this secret of your health? You are talking of healthcare, advertisements, this, that. Of course, the only thing that he said is, I have enjoyed everything in life. I am happy. The only caution that I took was, I never bought stress and strain. And that is why I am healthy. Wealth is not a problem for me. And it is for you to judge whether I am wise. Stress and strain for you. This is your functioning. This is what was being taught. That is what being expounded to you. And one of the illustrations given by Mr. Srinath was about what do you do, how do you compensate if the left eye has been operated instead of the right eye. It is something very, very speculative, but it can be calculated. But how this calculation and speculation has to be brought together. I am no exception to it. I was just now mentioning it there. Instead of the right foot, the left foot got operated by none else than by one of the famous hospitals of Delhi, Fortis Hospital. And the legal battle commenced immediately after the patient came out of the operation theatre, because the father of the patient, he was so baffled that he started shouting. Guards came, police came, press came, FIR was lodged, everything was happened. Both the doctors who had performed Fortis Hospital, within 36 hours they were dispensed with. A lot of drama took place, but ultimately 4 writ petitions, 1 criminal complaint. Writ petitions were in relation to the action taken by the Medical Council of India in suspending their licenses. All writ petitions answered against them with ₹1 lakh cost. Matter goes to the Supreme Court, SLP dismissed.
consumer complaint remains pending. And since 2014, the gentleman was about to become a chartered accountant in England. That was his status. He had come to see his parents, fell down from the staircase, broke his right leg. Now the defense was very exceptional. The defense was that when we took him inside the operation theatre, there was a lot of swelling on the right foot. And obviously it was surgically impermissible. Therefore we followed medical protocol and left it. But why did you operate the left leg? So they come up with a defense that the left leg had a hairline fracture in the ankle. So the contest was throughout that does a hairline fracture require a surgery and nailing? They had nailed it also. Obviously, the All India Institute of Medical Sciences in the medical reporting case, while taking a decision to the ethical committee, said that no, this is not medical protocol. For a hairline fracture, you only put in a plaster for 6 weeks and that's all. So this is the extent that you will have medical cases, but the issue is how to compensate. How do you quantify? Now in this case, the gentleman said that I was a potential candidate for a chartered accountant. Had I not met with this accident, I would have completed my chartered accountancy by this time. I would have earned this much, and my life span has been reduced because of my non-functioning for another couple of years. I had to keep a servant, I had to keep a driver, I had to keep a... And all these allegations were bald allegations. Without any proof, how many drivers did you keep, how many servants you had employed, how much money you paid, there was nothing. Now the brilliance of the lawyer, he catches this and he says, leave aside everything. Senior advocate from the Supreme Court. He says, my lords, you don't have pecuniary jurisdiction. This is after all the battle up to the Supreme Court and everything done. Fortunately or unfortunately, it was left for AP Sahi to deal with it, but nonetheless, I did. So, he says, you have no pecuniary jurisdiction. I said, why? Well, there is no foundation laid. No material as to how he has computed, and he had computed about 18 crores. Of course, it was a figure arrived at by just mentioning some figures. The relief clause says so many crores. It will come before you also.
Yes.
So the question is, how do you compute? He has lost something. His loss has been acknowledged up to the Supreme Court. Negligence practically stands established with all this litigation that yes, they were negligent. There is no doubt on anything. But how do you compute? How do you progress? And the lawyer argues that if there is no material, then you have no pecuniary jurisdiction because you are above 2 crores. The 18 crores is without foundation. So you have no pecuniary jurisdiction. Well, that was not very hard to deal because the National Commission is the apex body and it exercises the ultimate jurisdiction. It can increase, it can decrease. Fortunately for him or for me, he cited the very same decision which I had in mind. Charan Singh's case, 2008 Supreme Court, where the case was for this, the pecuniary jurisdiction, where the National Commission said, yes, there is nothing. That was a case pertaining to death claims of 7-8 ladies in a hospital incident. So they had made speculative claims. Some of them were 80 years and above age. How have you calculated? How can you uniformly say that this would be the compensation for each of them? So then they said, we are dismissing this complaint.
you go back to the district forum and if the district forum decides that we don't, I think that was too far-fetched. But in the same judgment, they later on also referred to Charan Singh's case, a 3 judges decision of the apex court, which says that the National Commission has the ultimate jurisdiction, pecuniary jurisdiction, and therefore, even if it comes to the conclusion that the relief is to be granted much lower than its pecuniary jurisdiction or higher than that, it has that authority. So I applied that and I rejected that pecuniary jurisdiction aspect. But then again, how much to give? So it was, I must confess, whatever I speculated, whatever I could think about, I will not call it perfect reasoning, but it was something rational on the basis of the status of the person, his placement, his prospects, and the money that had been spent or he might have lost on account of this ailment. So I awarded 1 crore 8 lakhs. Now, you people and even I will feel bewildered. This was the point taken before the Supreme Court. Immediate SLP was filed and the SLP is dismissed, upholding our order with, of course, nothing on record. What reasoning impelled the dismissal, as usually happens. People say in the Supreme Court, the case has gone for a toss. So, God knows what happened there. He was not there, but the SLP was dismissed. Now, that order of the National Commission will be cited before you with a further rider that, look here, the Supreme Court has dismissed the SLP, you please take a similar view. Every case is decided on its own facts. So don't take the quantum to be a precedent. What you take it as a precedent, that compensation should be awarded, but evidence should be there. The reason is, it is a fact that the gentleman had not provided any material in order to even speculate what should be the actual compensation. There was nothing on record, and the council was not wrong in arguing this, that how do you assess? It is here. I will request you. Now this is how you function. We are more on functioning. Workshops are meant to discuss functioning. How do you decide this and to what extent? I have in 1.5 years learned how to read something more, as I usually do. So that is a book that I have informed the faculty also, and I will share it with you. Medical Negligence by Michael Jones. Volume test was being carried out, being read out. Of course, all those you very well know, Jacob Matthew, you also know Martin D'Souza. Now there is one thing I would like to just remind you. Please take out Martin D'Souza's case at leisure, not now. But please remember the paragraph. Paragraph is 111. While pronouncing, when judgments are more in length, they are also in depth, after all it is the Supreme Court. But when they are in length, at times something is said which may not have been necessary. There the Supreme Court says that the members of the commission, that was a decision of the National Commission which was judged, and they said that members of the commission are laymen. And for them it is not possible to substitute their expertise in this area. That was just an obiter. But please keep in mind, your orders are subject to appeals, revisions, and then Supreme Court. So please don't write anything which gives the impression that you have pondered over it like a layman. You have pondered over it like an adjudicator, and for that you have to give reasons why you are awarding this compensation and not that. So there should be some rationale. So that book on, don't get disheartened. I was just now looking at along with Professor Vijay Kumar and Mr. Gupta,
the book was previously for 11,000 rupees, now it is 9,000. But it is worth reading and keeping because it entails all the issues that were being discussed by Justice Senthil Kumar, whether it is an error of judgment, whether it is in accordance with medical protocol, whether the quantum is justified, whether the error of judgment is negligence or gross negligence, whether it is criminal negligence or not. All these distinctions have been very minutely discussed, and I have taken a lot of guidance from that book, in the sense that in medical negligence cases, when it comes to quantum, it is, you don't need a barber to shave your head. It gets automatically hairdressed. So that is why I said stress and strain. It is very difficult.
This is just all. Justice Narasimha's order, yes. Having considered material in detail, we are of the opinion that the NCDRC has not committed any written law in fact, and that is the end of the matter. Thank you.
So this is how it is, that it should not appear like speculation. It should reflect some exercise, thoughtful exercise. When you are exercising the discretion, this should be not mere discretion but judicious discretion. So application of some rationale as to why he should be given this compensation. Somebody finger has been wrongly amputated, so you don't award him crores. But that physical disability will amount to such a loss. Please consult medical literature. It is not permanent physical disability. So therefore, you have to be careful. What is the nature of it? And that is why quantum of compensation from case to case, there cannot be a precedent on that. Now, why I communicated to you that this is essential, because you see, what the speakers really disseminated here was not just knowledge. While offering her thanks, she said that it was a treasure hunt. Correct? It is real treasure, and it is rather a treat before lunch to get such a lecture. It is knowledge. People say knowledge is power. You have to take it one step further. Just 1 week back, there is a column in Times of India. You will get, it is published, The Speaking Tree. In the Times of India, The Speaking Tree, and the books are also available in consolidated form. So, one of the exponents of Swami Vivekananda's followings, Swami Sukhbodhanand, he wrote a wonderful article. He says, it is not knowledge which is power as defined in our scriptures. It is the clarity of knowledge which is power. The clarity with which you have been informed today by the Chief Justice, by Justice Senthil Kumar, or by Mr. Srinath, you have seen it for yourself that it is their direct experience that they have transmitted to you. So experience is the best part of knowledge when it comes to your adjudicatory process under the Consumer Protection Act, because you are dealing with life of the citizens of every moment, which requires experience. But it is not necessary that you should experience everything before you write a judgment. That is not the issue. You have to experience the clarity of that knowledge from all sources and then apply it accordingly. So,
Procedure, I said, jurisdiction. You see, this form of assessment and approximation by a judicial verdict is one of the most difficult tasks. The reason being, if you cross one step of procedure, once notice is over, first there will be a fight on notice. The second will be on pleadings. Third will be on evidence. Fourth will be on arguments. And then when it comes for final arguments, preliminary objections. So, your steps are difficult steps, but the best way is don't hesitate, perform. Every day we are facing this 35(1)(c) application, class action not maintainable. Please reject it, the complaint. All right, we will decide this first. Go ahead. But don't leave it. National Commission, unfortunately, at least 100 cases I have decided where 35(1)(c) was pending from 2011, 12, 13, 14. It was awful to see. This shall be heard at the time of final hearing. Why? If the complaint is maintainable, decide it. If the person is aggrieved, he will go ahead. But why should the complaint be kept pending for that? And if it is not maintainable, reject it so that the other side goes. So decision on all preliminary issues that will improve your functioning. And as a matter of fact, this part of function is very much necessary, which is entirely dependent on you. It is lawyer may take excuses, anybody else may take excuses, but we as adjudicators cannot excuse ourselves from deciding. Why should any interim application be kept pending? It should be disposed of. If the person is not satisfied, go ahead. That's all. So, but there is, I'll wind up soon in 10 minutes so that you can enjoy your lunch. And then we can, if we find time, we'll continue thereafter, but I am available after only 3 o'clock because we are all confined on account of just a minute. Confined to the vagaries of yesterday night. I arrived at 2 o'clock. Flight was 1 hour late and 1.5 hours in traffic. So we don't know. The most important part which you have to face all the time is execution. So the steps of execution. Now, one broad clarity you should have in mind, which has been decided by the Supreme Court. It is not that I am saying. It is, but that clarity should be there in your mind all the time. Execution is not part of the proceeding. It is a separate proceeding altogether. Once a consumer complaint is decided, that is the end of the adjudicatory process of the merits of the claim. And unlike civil law, here also, you cannot go behind the decree. You have to proceed thereafter. But I am going to pose you a problem, and if we find time, I will like to have the answer from you, because I may have an answer to it. You may have a different answer for it. But I am telling you because this you will be facing every day. Execution is filed and when the execution proceeds, the judgment debtor takes a stand that, look here, the consideration has not been received by me, or I was not liable for it, and he sets up somebody or somebody else on his own comes up to say that I own the liability, but I was not a party there. How can you execute the ticket?
this problem you will be facing every now and then. Now the question is that I am posing to you, answer has to be given by you, not by me. I can give the answer, but by you. The question is, in such a situation, what does the law prescribe and what is the procedure? Now under the new act, all of you know, earlier it was 27 and 27 capital A. Under the 1986 act, there was no other procedure. Under the new act, you have 71 and 72, and now order 21 has come to your aid of the Civil Procedure Code. In contrast to that, under the 2020 regulations, you have regulation 26. No party will be allowed to invoke the provisions of the Civil Procedure Code. That is, the parties. Just read the wordings of regulation 26. It doesn't say that the commission is prohibited. Why? That is an implied understanding of it, which the Supreme Court has also ruled, that you are a summary jurisdiction, therefore you will not every now and then apply CPC. But what is CPC? It is rules of natural justice combined and codified together. So there are some principles of natural justice for which guidance can be taken. And now order 21 has been specifically applied. So when such an objection is taken, you all people very well know section 47 CPC. Huh? Yes, exactly. So how do you tackle with section 47 or such a person coming in execution? That is the question to you. Food for thought. You have to answer it because you can't go behind the decree. You cannot travel beyond what has already been said. On the one hand, you are being told here that you are a summary jurisdiction. On the other hand, order 21 has been applied. So to what extent can you stretch yourself, your jurisdiction, not yourself, but the jurisdiction that you are exercising to decide this issue, and how? We will talk about the answers later on, but before I end, I must inform you that there are many important decisions of the Commission as also the Supreme Court which you have to keep in mind. I was tempted to speak something more on what Mr. Srinath left was on the exercise of powers under the new chapter of the CCPA which has been introduced under the 2019 Act, that penalties etc. under section 21 are not powers of the Commission but they are powers of the authority. So therefore, if there is an unfair trade practice of the celebrity, how do you rope him in? That is a very interesting issue. In some other session we will be dealing with it, but please don't ignore it because this is what you are going to face. So the second question is, how are you going to face this too? Because it is a workshop, you will be there tomorrow. Maybe something comes to your mind, please ask these questions to those who will be coming tomorrow. And you are having very good speakers tomorrow of the same caliber. Justice N. Sundar is there, and I don't know, Justice Bharat Chakravarti is there. So both of them are outstanding, and I can vouch for them. I worked with them. That your questions will not go unanswered. And the third part of it is that when you delve into the issue of a trade practice being unfair, so is it bound by the definitions? And if it is bound by the definitions, how far can you go to treat one practice to be unfair, which will be obviously argued before you, this will also amount to unfair. So
Definition of unfairness. That is the third question posed to you that you should talk about amongst yourself and put a question from your experience. How many cases you have decided on unfairness and why did you treat a particular act to be unfair? Please keep in mind that the act has two sections. One is goods. So goods is defects. Services, it is deficiency. So how do you come to a conclusion that the trade practice in respect of a good or in respect of a service is unfair? These parameters are slightly different. I'll just end up by saying you must have come across cases of manufacturing defects in cars, in scooters, and all these things. I had the occasion to deal with it. I said, yes, manufacturing defect, if alleged, if not proved, according to expert, it will be difficult to impose anything. But I have gone one step ahead. Let the matter be tested by the Supreme Court. That the word defect has been defined under the Act. So it encompasses any form of imperfection. Why only a manufacturing defect? Because manufacturing defect is limited, which is a defect that might have occurred during the manufacturing process, or the defect might have surfaced on account of such manufacturing defect. But how do you not indemnify if the vehicle is within the warranty period? Will it confine only to the terms and conditions of the warranty? A vehicle is being taken to the dealer for 10 times. Not for fun. Nobody goes to for fun. Why is he going there 10 times? And you say that it is not a manufacturing defect. Then what is it? It is a defect. It is an imperfection which is being pointed out to you within 2 years of the purchase of the vehicle. Whatever work it is, of course, doctrine of proportionality will apply. You will not replace the entire vehicle. You will not replace the entire engine. But this deficiency in service should not be done. And therefore, you have to take care of it. There are simple methodologies prescribed, and there are at least half a dozen Supreme Court decisions to that effect, which you will find to help you with that. Last but not the least, one aspect was given to you about evidence. That you see, there is a lot of hearsay evidence also. What is hearsay evidence is something which you cannot vouch for or prove. Is hearsay evidence. So you have to be careful that whenever such evidence is brought forth, allow the parties to serve interrogatories on cross-examination, if necessary, not in every case, or exchange of affidavits itself, to clarify, because you have to give the reason for your decision. They will get off by saying that I have said this was not considered, that they will take. So therefore, be careful in this, that whenever it comes to evidence, particularly hearsay evidence, you have to record your finding on it, that this is hearsay evidence or whatever you find it on evidence. Before I part, there is one subject, and I will request the organizers here that please keep that subject whenever you hold a workshop with which our judges are struggling, members are struggling day in and day out, and that is the problems arising out of this modern technology of digital platform, where hacking, where problems arising out of electronic equipment, assessment of the various vagaries of this electronic world, which is a purely technical subject. Artificial intelligence, belief of evidence. This topic should always be kept in a workshop, because we are moving and the entire world is moving towards the digital platform. Crimes, civil wrongs, compensatory damages, they will all be governed by this new contemporary topic, and there is a lot of material on it. I had brought it, but it will consume a lot of time. But nonetheless, I am throwing this that the organizers should always keep one session so that our participants are abreast of it. And just before I leave, one recent issue, which of course some of the speakers also wanted to know, and it is there in the newspaper also, which you can read. I have all the printouts. I have given it to Mr. Gupta. You can have it. From an Apple telephone, you are booking a hotel. The price is 10,000. From an Android, you are booking it. From the same service provider, it is giving it to for 6,000 or 7,000 rupees. What is this? So this overlaps the competition law, but at the same time, is it not unfair trade practice? These cases will be coming. I wish that this technology of pricing algorithms is studied by you. You have to study it in advance, because let not technology outpace judicial approximation. Let judicial approximation chase technology and answer these problems. So thank you very much. We will meet if time permits after lunch.
Yes.
Do you know what has happened with Confonet? Are you aware of it? Are you aware of it? What has happened? That is why you are putting this question. What has happened is that this Confonet system is run by NIC and all these people. And the government gives the funds for its operations, including the operation of the functioning of the server of the Confonet services. Server has its limitations, and therefore every year they hire the cloud services for which they have to pay. This year they did not pay for the cloud services. This is what I have come to know. But I do not know whether how far it is correct. They are still investigating it. I have written, of course, an administrative order that we will be accepting all physical filings, because problems of limitation, problems of written versions being filed were arising because of this Confonet, or limitation with regard to filing of appeals, revisions and orders not being supplied within time, not being uploaded, or uploaded, they are not on the Confonet. We were facing this, therefore we have issued that directly. At the same time, I have written a 2-page letter to the ministry, and my ministry has written it to the Information Technology Ministry, but what will happen I cannot say. But it is a fact that it has crashed. So this crash of the server and the non-availability of a cloud services is probably causing the problem. So you will please, all of you, allow physical filing and take care of it, that it is the litigant who ultimately suffers. None of us suffer. So therefore, please take care of the litigant, and please write in your order that it is because of the failure of the Confonet facilities that this order is being passed, or something like that. Make it a point to write it. So that is your answer for what I can't answer anything more, because the government people are not here. So, thank you very much.
Thank you, sir, for your valuable resource. Before vote of thanks, I am requesting Honorable Justice Mr. A.P. Sahi, sir, to hand over the book which had been released today to Mr. G. Salim, member DCC 1 Chittoor, Andhra Pradesh. I am inviting G. Salim, sir. For giving a brief vote of thanks to our respected resource person, I invite Dr. S.A. Samira, Women Member, DCDRC, Ongole, Andhra Pradesh.
Distinguished guests, honorable presidents from various states and esteemed members from various districts of consumer commissions, the organizers and entire team of Dr. Ambedkar Law College and the students, a very good afternoon to all of you. As we are come to the conclusion to the second day program of capacity building program, it is my great honor to give a vote of thanks on this great occasion. He is the person, he is the eminent person who has enlightened, who has enriched the discussion with his valuable insights, none other than our esteemed Honorable Mr. Justice A.P. Sahiji, President NCDRC Delhi. Sir, your valuable insights are very much helpful and create a wealth of knowledge to enhance our understanding and capabilities to redress our consumer grievances. At the same time, your discussion shed the light on functioning of consumer commissions and the various issues involved in enforcement and challenges faced by the enforcement proceedings, and as well as the involvement of the technology and AI and deficient product, manufacturing defect, and everything in each and every scenario. Sir has given the valuable insights. It will definitely helpful for the redressal mechanism, robusting the redressal mechanism of to safeguard the consumer rights like the sensitive area of health sector and etc. And next, I extend a heartfelt thanks to the organizers for their tireless efforts and dedication have been truly commendable. And finally, I extend my sincere thanks to all the participants who have patiently and dedication, who have put their dedication throughout the entire session and make this program very significant. Not the least, I would like to thank all the media people, electronic media, printed media, and all the administrative department and management of this hotel. And once again, I would like to thank each and every one of you.
Thank you, ma'am. A humble request to all the participants here. So, as you all know, we have a field trip to Auroville Matru Mandir, and it is a special request permission that we have got. If you can check, the Matru Mandir is available only till the morning session. So, evening session is specially open for you. So, let's not miss the opportunity. We will not be able to extend the time. So, please complete your lunch in 20 to 30 minutes and try to